Morning, everyone. Welcome to the Michigan Supreme Court's April case call. Nice to see you all in the courtroom. We have 4 cases to hear this morning and 1 this afternoon. The first one is a full grant with 20 minutes of argument per side, Township of James versus Daniel Rice. So we will get started with that case when you are ready, Mr. Ellison.
Thank you and good morning. Philip Ellison appearing on behalf of the appellant this morning. Your Honors, in a normal case involving attorney's fees, many courts, both trial and at the Court of Appeals level, see the word may in attorney's fees in the same sentence and assume that it gives the court sole and unlimited discretion to decide whether to grant those attorney's fees and in what amount. The issue here today is not whether Mr. Rice is entitled to protection under the Right to Farm Act. That's already been decided and is not before you. And the issue is not the amount of the attorney's fees either, because that hasn't been decided, and that's solely, and we've admitted, within the discretion of the trial court to decide. But the question today is who gets to decide? Who has the discretion to decide whether those attorney's fees should be awarded in the first instance? And it's our interpretation and it's our belief that the way the Right to Farm Act has been written, similar to the way that the bankruptcy code was written in Law v. Stiegel, that it requires that the farm or farm operation is the one who gets to decide whether those attorney's fees should be granted and leave to the trial court the decision as to what is the actual and reasonable amount to be incurred. We think that the lower courts below simply go on autopilot when they see the words may and attorney's fees and don't read and parse the statute correctly going forward. Now, the reason for the Right to Farm Act, very briefly, is the fact that this was an act designed to actually remove an impediment to the difficulties that farm and farm operations of all sizes have. We don't need to look very far right now in the news to see that farms are suffering from increased input costs, whether it's seed, fertilizer, or pesticides. And one of the things that affects farmers and farms operations is when the government interferes with their operations. The whole point of the Right to Farm Act was to remove the threat that local governments incur or impose upon farms in the operations of their activities. This provision was meant to provide the tool to the farmer to decide whether or not he wanted his expenses, when found that he had the right under the Right to Farm Act, to be reimbursed. I welcome any questions the court may have.
What discretion does the trial court have in this for this question?
It's the last half. It's the very last portion of the statute itself.
Could the trial court still come up with an award of 0, even under your interpretation?
I think the answer is no. It has to be a reasonable and actual attorney's fees. So the amount would be, the court would still be in a position to decide what a reasonable amount would be.
Could the trial court, if we were to agree with you, could the trial court nonetheless come back with 0 if they determined that your client didn't timely assert a right to farm claim?
I disagree. I think the answer is no. And the reason being is that discretion on the first half of the statute was provided to the farm or farm operation. The legislature cleaved that grant between the farm and the farm operation and the trial court. Now, I will admit, in many statutes, the trial court has both of those elements of discretion.
I guess the question I'm trying to get at is if the trial court determines that your client didn't timely inform that I'm asserting a right to farm act claim here, and all attorney's fees before that assertion are not reasonable, would that be an abuse of discretion?
I think it would be an abuse of discretion.
Why?
Because as I understand your question, that the outcome of that determination would be that the attorney's fees would be 0. I think
no, I'm just talking about up to the point where they actually assert the claim. Any attorney's fees accrued before that point, could the trial court conclude that that's not reasonable? You should have asserted this more timely.
Well, that would be a question as to whether it would be reasonable or not in that respect. But
so you would agree that they could come back with 0 for that?
I disagree. And I think the reason being is that the closest parallel I can draw this court to, which has not been briefed to you today, would be a case called In Re Estate of Nash versus Grand Rapids. And in that case, I think the Court of Appeals got that case wrong too, which I think that parallels here. And of course, just to be forthright, that's what attracted me to this question to begin with, because in the case of In Re Nash Estate, the Michigan Court of Appeals held that in the FOIA statute context, that when a partial prevailer, meaning they prevailed in part or didn't prevail in part, The Court of Appeals said that they could grant $0 in that respect, and I believe that's an error. This court has never spoken to either of those propositions, and it was not addressed because the Nash case with the FOIA issue was simply a side issue that got pulled in the Court of Appeals, but didn't get pulled up to this court ultimately when it heard the case on the underlying merits issue for that case. So I guess the short of this would be is that I think that it's very tempting to say, let the trial court decide all of it. But that's not what the legislature did here. And I think we need to be faithful to the terms of what the legislature tried to do here, which is give the power back to the farm and farm operations in this particular instance. And it can't be a surprise because the whole purpose of the act was to re-empower the farm and farm operation to be freed of improper harassment by a township. Now, and I don't want to say harassment in bad faith, but I am saying harassment of any type, whether good or bad faith in that respect. One last point, I guess I want to dovetail on your question in case there's any other questions from any other panel. I know there's been a reiteration by my brother counsel in this case that my client didn't assert the Right to Farm Act soon enough, and I think that's kind of where your question's going. We dispute that. If you look in the court record itself, it's not attached in the appendix. If it is attached as the single exhibit to the reply brief in the Michigan Court of Appeals briefing, the second briefing, if it were the second case, the assertion is that the township zoning official did not know that Mr. Rice was asserting a Right to Farm Act defense. In a letter dated April 9th, 2018, Mr. Gray, the code enforcement officer, recounted that my client called him and asserted a Right to Farm Act defense before the ticket was issued. Because if you look at our Appendix 1A in this court, that ticket was not issued until 2 months later. They did have notice, and the record here is clear they did know that before they ever stepped into court. And when they did step into court, the record is clear that the Right to Farm Act defense was raised throughout. It was only after I took over the case from predecessor trial counsel at that time that we then essentially kicked the township off the property and said we're not going to participate in a post hoc inspection process going forward. So the Right to Farm Act in this case, and I know it's a question I think that comes up, is to say if we give the discretion to decide if the fee, could the backdoor way the trial court could eventually get the outcome that they want would be is to award $0. I think that's being unfaithful to what the legislature was trying to accomplish with that particular statute. But I don't think we...
Mr. Ellison, what if in a particular case a litigant did not have a lawyer, asserted the Right to Farm Act, did not have a lawyer, and the court determined there were no costs in that situation? Does the court have the authority to assess, is $0 a correct amount?
Again, I would divide this into a two-step process, but to answer your question would be, one is that if the farmer asserted the right to attorney's fees and costs, the answer would be they would be entitled to them. But as this next step was they didn't have any fees or costs, then they would have nothing then in that respect.
So you agree that
yes.
Yeah,
so it's not like and I guess to parallel this is not like a 1983 action where someone's always going to get fees in that respect. It's only those that are, and that's what I think is unique about this statute. It's not a reasonable attorney's fees. It's reasonable and actual attorney's fees in this respect.
How does that help you?
How does that help me? What that does, I don't think it helps me. I think it distinguishes from the case Chief Justice McCormick pointed out, which is if you have a situation where someone comes in and they don't have any attorney's fees, a pro per, for example, can't demand an attorney's fee on the basis that they're entitled to like a reasonable fee, which does and sometimes does happen in federal court 1983 litigation.
But the operative word is and, so reasonable and actual.
Correct.
So if the court determines that the actual fees are not reasonable, you get nothing, right?
Well, of course, any lawyer that's demanding a fee, and there's a case called Zorin, and I know that because I was the lawyer on that case. The Zorin case says that any fee that a lawyer demands has to be reasonable. Otherwise, we would be running afoul of 1.5 of the Michigan Rules of Professional Ethics. All of our fees, even actual fees, is subject at all times to a reasonableness analysis through our ethical
You didn't answer the
obligation.
question.
Well, I think I did, though.
If the
but
court
I guess,
determines it's not reasonable, you don't get your actual fees, correct?
correct.
Okay.
Correct. So, for example, if I was in a sneaky way, knowing that I've got a really great Right to Farm Act defense, have a contract with my client that says you're going to pay me $10,000 an hour for services, Those would be, my actual fees would be $10,000 an hour. But I think with the and there is that would be subject to a reasonableness. I don't think, and that's a stretch, because our case law in Michigan, at least at the Court of Appeals level right now, is all fees, whether they're actual or otherwise, are always subject to a reasonableness analysis. And I think here the legislature just put a belt and suspenders in that respect. So, long story short here, I leave the court, unless there's any other questions, would leave the court with, in this unique circumstance, much like the analysis in Law versus Stiegel that the U.S. Supreme Court did, the legislature took what is normally a mashed together process and separated them out into two, and gave the farm and farm operation the decision to require whether there's going to be an award of attorney's fees for a successful invocation of Right to Farm Act, and the determination as to the amount, which is needs to be reasonable and actual, belongs to, still remains with the trial court in the traditional sense.
Counsel, but why would, I'm just sort of, I'm wondering where the may recover, why would a farm operation ever opt not to get attorney fees?
Well, there's a couple situations. One I could think of that, just from my own personal experience, is the farm would say, tell you what we'll do. We will waive our attorney's fees in this particular, because some of these cases can be very expensive. I mean, they can go on
Sure.
for a very long time. We will waive our attorney's fees provision if you agree to do X, Y, and Z. For example, don't bring any more changes. For example, one of the ones I could think of is the Clay Township case that was cited by my brother counsel. They worked out an arrangement in that case. Now that case fought about whether they were prevailing parties or not in that respect, but it highlights an example of where a farm can sometimes say, I have a greater interest in getting something from the township and will give up my rights that I have to the attorney's fees award in that respect. Again, when you contrast that against what the Right to Farm Act was designed to do, which was to empower farm and farm operations, it makes sense. It makes sense in that respect.
So shouldn't it have said shall recover then?
Well, then that makes it mandatory then, and that means the court doesn't have, the court and the farmer doesn't have, again, we're talking about step one, step two. At step one, the farmer would not have the option to waive that in that respect. Now, I know in a practical respect, we as lawyers and litigators out there will sometimes forego attorney as a part of a settlement agreement.
Yeah, I was going to say settlements do
A
that all the
settlement.
time.
But a settlement agreement is a private agreement between parties. It doesn't dictate what the process of what the courts and what the law requires. In this respect, the legislature gave the farm and farm operations the authority, the discretion to decide whether to make that award, and the amount still as a check, if you will, by the actual court itself.
Thank you.
Thank you. Unless the court has any other questions, I appreciate your time and to be back in the courtroom today.
Thank you very
Thank you.
much. Mr. Campbell.
May it please the court, Gary Campbell on behalf of James Township. This case, began in the Saddle County District Court when our ordinance enforcement officer alleged a breach of blight ordinance, zoning ordinance, and Michigan residential code. These were three allegations. One went toward a lean-to that was being attached to a building that had been used as a car repair shop. And then the zoning ordinance was on the height of the fence, and then the blight ordinance was regarding the junk and debris that was on the property. When the case first began, at that hearing in July, the only issue that the defendant brought was the lean-to aspect. He said that the lean-to was used for agricultural purposes, and that was the only thing he alleged at that time. And then when we went to the hearing in August, they then added the fence on as another aspect of right to farm. And then we went in October, they then again added the junk and debris that was on the property, and that was for agricultural purposes. So gradually, as month went on, they kept adding more things to it. And actually, the court's order in September had granted the Right to Farm Act, but then stated it did not include junk and debris and the junk cars that were on the property. Now, the issue the court wants to hear today involves whether the statute, is basically automatic. Does it mean that the farmer automatically gets the cost and attorney's fees, or whether it is subject to the discretion of the court. And our position is that when this statute was enacted in 1995, it was an amendment to the original statute, that it did give a right to attorney's fees because that had to be placed in a statute in order for attorney's fees to even be granted in the first place under the American rule. But it is our position that it's still discretionary because the court used the word may rather than shall, and the courts have dealt with the may and shall argument a number of times.
Why would it make
past.
any sense for the legislature to use the word shall? Isn't it, if we accept appellant's interpretation, isn't it going to be up to the aggrieved party? Maybe they're just tired. They've seen enough. They don't want to go into court one more time even to ask for attorney's fees. I can't see the use of shall ever. You cannot require a party to affirmatively take action in litigation. It seems to me that that's not a very strong argument. It would never say shall. Can you identify for me one statute where the legislature used shall to require a party to go into court and litigate something?
Well, I can cite one case, Your Honor. I've cited this in my brief, but didn't I go into great detail on it? And this is the case of Newport West Condominium Association versus Venier. It's 134 Mishap 1, 1984. And in that case, this does not involve the right to farm act. It involves
134 Mishap.
I'm sorry. It's 134 Mishap 1, 1984.
Okay.
It's Newport West v. Venier. In this case, it's under the condominium statute. Apparently, some of the residents in the condominium were upset because the association had misspent association funds in not using it for the purposes for which it was designated. So they brought in action in court. And under MCL 559.206 sub B, at that time, the statute said, in a proceeding arising because of an alleged default by a co-owner, the association of co-owners, if successful, may recover the cost of the proceeding in such reasonable attorney's fees as may be determined by the court. It's sort of similar language as we have in the Right to Farm Act provision. And in that case, the Court of Appeals decided that they would not grant attorney's fees considering the facts and circumstances of the case. They felt that the co-owner had basically brought this issue forward and he had basically served a purpose for other co-owners. But interestingly, in 2000, the state legislature amended that ordinance to state something different. Rather than saying may recover, they put in shall. And so they stated in that new amendment to that statute, it said, in a proceeding arising because of an alleged default by a co-owner, the association of co-owners or co-owners association, if successful, shall recover the cost of the proceeding and reasonable attorney's fees as determined by the court to the extent the condominium documents expressly so provide. So in that case, they did use shall rather than may in that particular statute.
Okay, that one presupposed that there was already litigation ongoing, and as I understand it, as you read it to me, that would suggest that the trial court has to do this without a motion from the party who wants it.
It's good. I have not seen any cases since that time, since that amendment, but in the previous amendment with the may, the Court of Appeals did not grant the reliefs, the attorney's fees sought in the original statute.
So you see no difference between the trial court may award fees versus a prevailing party may recover them?
I guess my view is that may recover, my view is that the may recover indicates that now the farmer has the ability to request attorney's fees. If that statute had not been there, he would not be able to do that at all because you cannot seek attorney's fees unless you have a statute or court rule or a contract.
Right, you're telling me the discretion lies in the farm owner.
whether he wants to bring the act.
Correct.
Well, right, well, he had that, right, if he wants to make a claim for attorney's fees.
So if the may relates to whether the farm owner wants to bring the claim for attorney's fees, why do you assert the discretion may also applies to the trial judge refusing to grant fees?
Well, I think in this case, the statute says that the farmer may recover as determined by the court. I think there's an ongoing continuation of that phrase. We're trying to view the statute as a whole and not just parse it out. I think that it gives them by having the statute there, it gives the farmer the right, but then it relies upon the trial court then to determine the facts and circumstances whether attorney's fees should be granted.
Right, well, it gives the trial court the authority and the discretion to determine what is reasonable and actual.
Yes,
Not you've prevailed and I've decided to give you nothing. The court would have to determine, is it reasonable and was it actual?
yes, because the court would have to exercise its discretion, which is that very thing, that it has to be reasonable and has to have proper outcome. There has to be a basis for it. It cannot be arbitrary or discretionary. It has to be based upon the facts that are before the court when it makes that decision.
On this record, do you think the trial court determined that it wasn't reasonable or it wasn't actual, or did the trial court just determine, I'm just not going to award any fees here, I'm tired of this case?
Well, from the information that we had, we argue these things at every level. We argue these things in July, August, October, that we were unaware of the claim that we were trying to put down a farm operation. Township certainly had no idea or intent to close down a farm operation. We didn't know it was a farm operation. And that information only came to us because the farmer or the resident, he's in a residential area, a rural residential area. It's not a farm. We never saw any crops, never saw any chickens, we never saw any of this stuff. But then he was making a claim at each hearing that he was doing this or using this for that, or I'm storing this for this down the road. And at that time, I think the court saw all of this. So granted, the court did not mention the reason, but I think the court certainly was aware of what was going on during those various hearings we had.
So if we conclude that the may relates to the farm owner's opportunity to seek recovery of reasonable and actual attorney's fees when they prevail, and that the trial court didn't actually make findings as to whether this was reasonable or actual, wouldn't that merit a remand?
And that's what the Court of Appeals did, Your Honor. They sent it back to the district court for an explanation for its reasoning for why it did not grant attorney's fees. And so we had a hearing, opposing counsel objected to the court making a decision at that time, so that reasoning was never done before coming here today. I think I've explained our other issues at the various cases we've had, so if the court has any other questions, I'd be happy to answer those.
I don't see any more questions. Thank you, Mr. Campbell,
Thank you.
for being here.
Very briefly, in response, I just want to make sure the record is clear about, I did indicate earlier about the letter that predated the issuance of the citation. I would also point this court to Appellee's appendix number 2 and number 3, which was the first hearing, July 2nd, 2018. On those pages, the Right to Farm Act was asserted right from the beginning of this particular case. So this idea that we just didn't know is a false assertion to this court. It's not accurate compared to what the record reflects in this respect.
Even if we agree with your interpretation of the statute, is there not need for a remand?
There is need for remand. The problem here is
Can you distinguish that from the remand the Court of Appeals requested?
I was just going to get to that. What the Court of Appeals did was it said the trial court had the discretion to decide to deny attorney's fees.
Deny outright, right.
We just want to boost the record as to why you did exercise that discretion. What I'm saying is that the court, and not to repeat but the step 1, step 2 that's available here, So there is a remand that's required, it's just a different set of instructions need to be granted. What I think this court should do is remand and say that the farm and farm operation, based on this record, has exercised their discretion to be entitled to an award of cost and attorney's fees. Trial judge, which in this case would be a district court judge in Saginaw County, your obligation to decide is what is actual and reasonable in these circumstances under the last part of the statute.
I just want to clarify, it's not just actual and reasonable, right? It's reasonably incurred.
So,
Actual costs that are reasonably incurred by the farm.
correct. So you are correct in that respect. The language is, it's reasonably incurred in the farm, reasonably incurred is in the first about two-thirds of the way down. And the last very clause of the sentence is together with reasonable and actual attorney's fees. So the reasonable aspect comes in there in two different parts of that within the same statute itself.
So in your example, even if the fee is, that you charge is not $10,000 an hour, say you charge a reasonable fee of, I don't know, $300 an hour, that could still be characterized as not reasonably incurred by the farm, right? If the trial court determines that, for example, it was raised too late or it wasn't a reasonable assertion, I don't know. But it could be a reasonable fee amount-wise and not reasonably incurred.
That's a really good question. I never thought of it that way before that way.
Thanks.
So I guess the answer, I mean, just spitballing it up here would be yes. I mean, that would be the logical outgrowth of that. The difficulty, I guess, on this record right now with trying to answer that question on the fly here would be is that none of this was parsed out at the district court level. What was done is denied without explanation. You know, whether it was denied because it wasn't reasonable, was it denied because I just am exercising my discretion and I'm going to award it, we just don't know in this respect. So that's an interesting point, and I'm sure someone at the other table is taking some notes right now on that, but I still think the issue gets back to with the way that the legislature wrote this statute, which is such at odds with the way they write every other attorney's fees statute, including the FOIA one that I give you the example here, that I think it dictates a different process than just simply the autopilot of I see attorney's fees, the trial judge gets to decide all of that.
Okay, thank you.
If else there's any other questions, thank you very much
I don't see
today.
any. Thank you very much.
Thank you.
Case will be submitted.